We all got to pay for it, not you. Everybody. For the record.
All right, members, the House Criminal Justice Committee is now back into session. We are going to take the roll.
Representatives Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. When we left off earlier, we were on House Bill 2912 by Representative Warner. We had not adopted the amendment. That amendment has been added to your dashboard and was emailed to your offices during the intermission. So you should have had an opportunity to review the amendment. We were out of session. We had guests here to testify. We went back into session and then we took a recess. So without objection, we're going to go back out of session because there was questions by committee members and maybe some more testimony. So we're out of session. Y'all have anything that you need to add to what was said earlier, or would you rather have questions from committee members?
Happy to answer questions as far as my part.
Okay. Yes, sir, Representative.
Can we add the amendment first, Mr. Chairman, or do we need to proceed this way? I'm at your call, sir.
We're out of session. When we finish session, we'll come back in and address the amendment.
Thank you, sir.
Chairman Halsey.
Thank you, Mr. Chairman. I appreciate it. And thank you, gentlemen, for being here. I would like to ask the gentleman who used to be with the FBI, the way it looks, if I were to say that the FBI has become weaponized and is targeting good people in this country and framing them up as an enemy, would I be guilty of, in their eyes, of being an enemy of the government and charge me with domestic terrorism?
Well, Stephen Friend, former FBI special agent, the way that the FBI and Department of Homeland Security have drafted currently a strategic assessment on domestic terrorism that is publicly available was drafted in May of 2021. It defines a profile of someone that's labeled as an anti-government, anti-authority, violent extremist. And that profile is someone who has a perception of government overreach or negligence or illegitimacy. So if you hold any of those beliefs, that would fit the bill of domestic terrorism as far as the FBI is considered.
Okay, can you explain a little more about how the FBI profiles and investigates somebody as a domestic terrorist? And have there been any shifts in the FBI priorities related to investigating domestic terrorism?
Fundamentally, terrorism is going to have a predicated ideology and an intention to carry out a violent act in furtherance of that. The way that we've seen it, though, evolve, especially from the national security perspective in the last quarter of a century since September 11th, when national security in this country went from preserving the Constitution, preserving the continuity of government, to a zero-fail mission where no American can die from terrorism, which in essence would require some level of tyrannical behavior. And the FBI got their assignment to be the sentry on the wall, to be the guard dog. But due to mission creep that's happened because the demand for domestic terrorism numbers, because the FBI has a quota system, to meet those, they've evolved what they define as actual domestic terrorism. And it evolved from legitimate terrorist actors to homegrown violent extremists who were Muslim Americans. And we've shown that these were citizens who were vulnerable and largely entrapped into plots that they were not predisposed to commit, like the Liberty City Seven, who it's still to this date, they were arrested in the early 2000s. It's still the largest Al-Qaeda arrest in the history of the FBI, and not a single one of them was a member of Al-Qaeda. And that evolved then into domestic violent extremism. And that's been a term that's been in use more recently. And then you have parenthetical groups underneath that, like militia violent extremist or racially motivated violent extremist. But again, there's still a push for that because you will have like the Newburgh Four, who were just recently released from federal prison on humanitarian grounds. There were 4 African-American men who the FBI entrapped in the mid-2000s and actually got them to commit, they were vulnerable petty criminals according to the federal judge in her ruling on this. They were petty criminals who were not predisposed to commit any sort of terrorist act, and the entire plot was contrived by the FBI. And in fact, they involved a military installation so they could add a 25-year mandatory additional sentence to them. Now we've seen a further evolution into this new term, which is the acronym AGAVE, the anti-government, anti-authority, violent extremist. And we're seeing further evolutions into, they're saying, Christian nationalism, which is a way to get around the caveat that the FBI has for never investigating a First Amendment protected activity. But because they're able to connect it to something like racially motivated violent extremism and say, although anyone who goes to a church, they might be white, black, blue, green, orange, it doesn't matter. That is refracted through some lens of racial superiority mindset. We can investigate that. And that's the sort of the roadmap we've seen in the last couple of decades that has led to this weaponized FBI that's going after people who might voice some opposition to what the government wants to do.
Thank you. Sounds kind of like the Sedition Act of 1803, or if you speak against Congress or the president, you can find yourself in trouble. You answered part of this. Can you describe the kinds of cases the FBI Joint Terrorism Task Force works on, and how does it involve local law enforcement? How that play into the FBI Terrorism Task Force? Because your bill deals with this, or his bill deals with this.
So a Joint Terrorism Task Force essentially has 2 key areas of focus. It focuses on international terrorism and domestic terrorism. International terrorism could be like ISIS or Boko Haram, Al-Shabaab, those sorts of threats that come from abroad typically, and then domestic terrorism. But typically it, again, is what I touched on, where you have a predicated ideology that has been declared to be a problematic belief that believes in something that's adverse to our system of government, and then actually have a means to carry out and an intention of carrying out some sort of violent act. The way that a Joint Terrorism Task Force is structured is it has a component that is FBI agents, employees, maybe some support staff, but they don't have the personnel to actually carry forward effective investigations for an entire geographic area. So they will ask for members of other law enforcement agencies, federal, state, local, tribal, to nominate people to come to the FBI. They will be deputized by the United States Marshals and given federal arrest authorities. They'll be given credentials that say they work for the FBI. And then they will be assigned to the Joint Terrorism Task Force. And then they will do the work of the Joint Terrorism Task Force as cases come into the FBI. Now, as I articulated when I made my statement, when you are a task force officer, you get a security clearance, which means you have to have a need to know. And you're not allowed to talk about that with anyone who doesn't have a need to know, which I've made the case that disempowers a deputy who gets nominated by his agency to come to the FBI. It disempowers his sheriff, who the people in Tennessee in that county elected to be their chief law enforcement executive. And now one of his people who he's supposed to actually have oversight of is out working for the FBI on cases that sheriff might deem to be unworthy of his personnel, and he would have no knowledge of it because the FBI says the sheriff doesn't have a need to know. He's not actually on the task force.
So the sheriff, who constitutionally is the last line of defense against federal tyranny, doesn't know what's going on in his own county as far as these officers that's sworn in with the Bureau.
That is true. He would not have a need to know from the FBI's perspective. It would just be his personnel who they deem to be representatives of his agency at that point. But no one votes for the deputy. They vote for the sheriff.
Okay. One more question, I'm through. This gentleman that got arrested and charged, what exactly under the domestic terrorism umbrella, what part of that offense did he break in that law?
So Mr. Vaughn was arrested for a FACE Act violation, which FACE Act, it's a acronym FACE, Free Access to Clinics Entrance Act.
Okay.
And that's considered civil rights. It's a criminal offense within the FBI. What we are seeing, though, is an evolution, and it began, was exposed, I will say, a year ago when there was a leaked intelligence report from the FBI Richmond field office that said that people who were attending a Latin mass were prone to become anti-government extremists, not because they were going to the Catholic mass, according to the FBI, but because there were certain ideologies that were associated with going to the Latin mass that were problematic and made you prone to become an anti-government extremist. Being pro-life was one of those. Now, the FBI retracted, according to the director, retracted that intelligence report and has said that they're not continuing to do that. However, what we are now seeing is it being revealed by the same sources that were used to source that intelligence report. The Atlantic, the Brookings Institute, the Public Religion Research Institute, nonpartisan organizations that will finance studies that will say something like Christian nationalism is there are 30% of Americans who are sympathizers or adherents to Christian nationalism. And then they will say that although that is a protected First Amendment activity, the freedom of worship, that is associated with other beliefs that are problematic. And they will say it's refracted through racially motivated violent extremism, like white supremacy, regardless of whether the adherents are white, black, green, orange, purple. That's all refracted through white supremacy. And now the FBI has a duty and a responsibility to investigate domestic terrorism. One of the subcategories of that is racially motivated violent extremism. It's a way for the FBI to circumvent its own caveat where it says it does not investigate First Amendment protected activities. It now has sort of a hack around that system and connect that to, again, going to the Christian church. That is greatly associated. The Venn diagram overlaps greatly with holding a pro-life belief, which again would motivate the FBI to say that we need to recruit sources, open assessments, and investigate for potential anti-government extremism, domestic terrorism.
Okay, thank you.
All right, Representative Johnson.
Thank you, Mr. Chairman. So you are currently an FBI officer or special agent, or you were in the past? What did you say?
I'm no longer.
But you were an
Yes, ma'am.
FBI agent. And how long were you in the Bureau?
About 9 years.
Okay. And where was that?
I was assigned to the Sioux City Resident Agency, which is in the Omaha field office, and then was assigned to the Daytona Beach Resident Agency, which is part of the Jacksonville field office.
And then did you become a whistleblower? Did you get federal protection as a whistleblower?
No. Well, the FBI disputes that and says that I did. I was suspended indefinitely because they suspended my security clearance. They said that did not constitute a retaliation against whistleblowers. And there's now actually been proposed federal legislation today that's going to contest with that. But my actual security clearance was suspended for other things, according to the FBI.
Thank you.
Representative Towns.
Mr. Chairman, thank you, and thank you all for your testimony. Uh, Your violation, sir, allegedly so, was what? What did they say you did?
Sure. Paul Vaughn, person of Tennessee. What they said I did was to violate a person's civil rights to get an abortion. And so a First Amendment protected right to speech in a public hallway, talking to someone like I'm talking to you today, is all I engaged in. And at no time did I break any laws. I talked with police officers on scene, local sheriff, local city police chief. And 18 months later, they came and raided my house, as I explained earlier.
So did you actually touch somebody, or
And in no way.
were you intimidating with your conversation, your speech? Were you threatening?
I spoke just like I'm speaking to you today. I didn't get in anyone's face. I didn't get near anyone. Matter of fact, I didn't, the only people I really talked to that day were police officers. I didn't even talk to potential clients that day.
And you're saying that 18 months later, for that action, that the FBI came to your house and raided your house and took you to jail, I suppose.
Yes, they put me in federal custody, took me to downtown to the courthouse just down the street here. I was arraigned later that day and turned out on the street without any phone, wallet identification or anything.
And at that time, did you have a lawyer, or did you get a lawyer?
I did not. I have a small business in Middle Tennessee, but I don't retain lawyers as a habit, or
Right.
at least I did not at that time.
Did your people know where you were?
Nobody knew where I was. Not my wife, not my kids. They wouldn't tell my wife. My wife's asking them on camera, "Where are you taking my husband? What is this about?" And they refused to tell her.
Did not tell you what it was about either.
Until I was in custody in the car, they showed me an arrest warrant without my glasses, and I could see the capital acronym FACE, and so I knew it was some kind of pro-life related arrest. But I had no idea the details until I read the information at the courthouse here.
Well, to me, it's rather disturbing because, I mean, you have a right, as anyone does, to take their side. You be on whatever side you want to. And the FBI, nor the state government, nor the police should be able to intimidate you based on your side. But now, if you're in somebody's face with vulgarity and aggressiveness, that's a different statement. That's what
Absolutely.
democracy is all about. You can say and act accordingly. So, are you suing them, or are you fighting a case, or is it pending, or what?
Well, we've gone to trial. We've been found guilty based on rules of evidence. So we have to be sentenced July 2nd, and then we will file a vigorous appeal process to get this overturned. Once that is done, I have full intention of suing our federal government and the agents and all involved from Christian Clark on.
What state?
Tennessee.
It's in
right here,
Tennessee?
Mount Juliet, Tennessee.
Mount Juliet, Tennessee?
Yeah.
Okay. And how long ago did that happen?
This was March. The event was March of 21. The arrest was October of 22.
Okay, just recently. To the FBI agent, sir. Now, in the 60s, okay, during the civil rights movement in the Black community, we were familiar with a lot of shenanigans that were going on. Okay. And a lot of those things that happened that we know were unlawful, with the planting of evidence and enticing folk and terrorizing folk to say this, that, and other. But the FBI actually, no one is, unless you get someone like yourself to come through and point some of these things out, we can't deal with it and fix it. You've been there for 9 years. What do you think we need to do in order to fix the FBI?
Well, if you're not going to just get rid of the agency, I think one of the best things that we could do let's pretend that there was no problems with the FBI and everything was just going really well. I have proposed that one potential solution would be to actually disarm it. It's originally the FBI was not an armed agency. And then through the process that I sort of explained, the way that task force officers work with the FBI, we could do that to a greater extent and have task force officers, deputies, and police officers that work in the local area who could be sworn as federally cross-deputized agents. And the FBI could bring cases to the sheriff, to the police chief, and say, we've been investigating, or we want to investigate. Will you partner with us on that? And that would empower the local law enforcement to be the armed component to it, and would give sort of a bulwark against a weaponized, politicized agency, regardless of which side they're going after, because they're more accountable to the people and they're not incentivized by a quota system. I mean, the ticket quota, that myth about local police, no comment on that. But what I can tell you is the FBI has a system that needs to go away regardless of what we do, and that is called integrated program management. And that is a quota system that dictates the number of cases that they have to open and the arrests that they have to have and the tools that they have to use. And we're talking tools across the board, like we have to use a certain number of wiretaps every single year, which is the most invasive law enforcement technique out there. And that's completely driving outside of a politically driven agency. It's a bureaucratically driven agency because they're incentivized to bring the numbers up, to meet the standard and even exceed it a little bit, because senior executives at the FBI get $30,000 to $50,000 bonuses every year because the quotas are met.
Is that how the rank and file gets promoted as well?
Well, the rank and file, the promotion process is it's a different structure as you're moving up. So from a general frontline agent, the next step up would be like a supervisory special agent. And that typically requires you to go to Washington, D.C. for 18 months. And then if you're on that track, that career track, it's every 18 months you're looking to promote. But hitting the quotas is really relevant for compensation for people who are no longer on the GS pay scale, that's the regular one. It's the SES, the Senior Executive Service pay scale. It's part of their compensation package.
Now, obviously, we need people in our country that, because the world is not a safe place. Okay, in America, we have enemies. There's no question about that, and they can be foreign as well as internally. So we want people that can actually abort that, but we want it to be real, not setting up the citizens for nonsense or making a political statement in that nonsense. It needs to be genuine. It needs to be real. There should not be allowed no force. I don't care what it is, the police department, state troopers, anybody, be allowed to cannibalize the people, the citizens that pay all the bills. It should never be that. And where you have rogue cops and rogue FBI agents and rogue people that are doing the wrong thing, they have to be dealt with. And as I said, in the minority community, we see and have seen a lot of rogue activity in law enforcement for generations and generations. It's spilling over now in other places for whatever the issue is, but it cannot be tolerated because it's wrong. And you got to be able to trust with confidence that you people, that you allow to have really life and death on the hip, okay, to be fair and righteous as it relates to other human beings. I'm sorry, you're about to say something.
Yes, sir. I wanted to add on to what you're saying. Is I think that there's the strong case to be made that the minority community, particularly like during the civil rights movement, was extremely vulnerable. And as a result of that, they were sort of easy prey for an energetic and over-the-top law enforcement agency. And I think that there's a new category that we're seeing now, particularly people on the autism spectrum. And because we live in a digital society now, the new strategy, the new playbook is to encounter people who are emotionally disturbed, particularly those on the autism spectrum, and encounter them online, use an undercover or an informant, and they are actually going after minors, people under the age of 18, and encouraging them to become obsessive with something like terrorism, and then wait until they reach the age of majority and charge them with some sort of providing material support to terrorism.
Well, Mr. Chairman, finally, well, that's not going to solve the problem because you got the real terrorism. If you're inducing it, we consider that, and you help me, we consider that in the minority communities as entrapment. Explain entrapment to me, okay, from an FBI perspective.
So the definition between entrapment and sting is very close. Entrapment has to be shocking to the conscience from what the Supreme Court and from what the DOJ has said. A sting, though, allows you to use deception. You can lie. You can use undercover agents. You can use informants. That is all within the bounds. So I think the people, generally the lay person, our understanding of what entrapment is is the spirit of entrapment, but the actual letter of the law is not that far, which is why you're able to use those sorts of resources. And you have like Project Salam, which came out with its terrorism report, and this I think was 2014, and they looked at 400 cases that the FBI investigated from a terrorism standpoint, and only found 4 of them in which the person was actively doing terrorism without the FBI's involvement.
Can you use money and drugs? Can the FBI use money and drugs to entrap somebody?
They can use money as far as incentivizing an informant to go and provoke someone to do something. They can use money even like the Newburgh 4, where the informant offered $250,000 to the primary subject to get involved in, quote, a mission, which wound up being this terrorism ploy that the FBI was inventing. As far as drugging someone, no, the drug component is typically the other way. The transaction is you purchase the drugs from the seller in a narcotics investigation.
Mr. Chairman, thank you. Thank you both for your testimony.
Yes, sir. Thank you. Members, I will say we have heard quite a bit of testimony thus far. And so if we can, just I know that for the sake of time, maybe we can limit our questions a little bit, scale them back just a little bit. But if you need further information, I'm sure these gentlemen will be more than happy to give you their contact information. Next on my list is Representative Fritz.
Thank you, Mr. Chairman. I'll be really quick. Thank you all for your time here today. I appreciate it. And I'll direct most of my questions, sir, to you, if you don't mind. Did you, at your time in the FBI, see any specific attacks against parents at school boards, specific political ideologies, or universities?
Yes, I was deployed to a school board to go conduct surveillance at a school board meeting as part of the Joint Terrorism Task Force.
And may I ask, what was your objective there? What was your given objective?
Our given objective was to take down license plates of people who we knew to be communicating with someone who was actually a January 6th subject.
Wow. Couple more quick questions. Did you, during your time in the FBI, work with foreign nationals or mercenary type elements that were in collaboration with the FBI?
No, I didn't.
And you mentioned need to know. Could you just describe for us again what a violation of need to know is, and what's the penalty for both the one who does the speaking and the receiver of that?
Well, and need to know is it's connected to your level of your security clearance that you have access to, and you even with if you have a security clearance and a top security clearance, unless it pertains to the matter that you are tasked with investigating, you don't have a need to know that information. You should not seek that information. No one should give you that information. If you violate that, you can be criminally charged, or it could be something to the effect of you just lose your security clearance. You can be terminated from work, but you could face federal criminal charges for that.
One last question. Thank you, Mr. Chairman. Can you talk about what your action was that resulted in you being a whistleblower?
I was concerned with being on our Joint Terrorism Task Force. We had a January 6th subject who we'd interviewed and then had not spoken to him for 18 months. In his interview, he said he would cooperate, and our division decided to send a SWAT team to his house. So I was a former SWAT operator. I've voiced concerns about that. And then I also said that the FBI departed from its rules for the way that it manages those cases. And it essentially took one case and turned it into thousands of cases to support the domestic terrorism numbers that we had for quotas and get bonuses for senior executives. So I took those to my senior executives in my own field office. And then they said that I looked at the employee handbook improperly, and that's why they suspended my security clearance.
All right, Representative Gillespie. Representative Hardaway.
Thank you, Chairman, and good afternoon to you, gentlemen. I'm still trying to get clarity on who's who here. All right, so the gentleman in the darker jacket, you were arrested at a clinic.
That's correct.
All right, and what was the charge?
Yes, they charged me with FACE and then with an 1880s conspiracy against rights statute, saying I violated the rights of people trying to seek an abortion that day.
Okay. And I'm assuming it
and
went
that-
to trial?
Face was a 6-month misdemeanor. The conspiracy is a 10-year felony, just to put that in perspective for us. We've gone to trial, yes, and found guilty through the evidence, rules of evidence and the things that have gone on there. We have an appeal pending. We can't appeal the project until sentencing takes place July 2nd. So that's where the case currently is.
And so what specifically, were you charged with obstructing the patients from coming in or the employees from doing their job?
Sure, because I ideologically agreed with people that were arrested that day that sat down and did a sit-in. So they blocked the door, broke the face law. But because I was in agreement with them ideologically and on site with them, they said I was part of a conspiracy to deprive these people of rights. So that's the hook they used to drag me into the case. Although my actions that day, as I explained, were nothing more than what I'm doing to you today. I was just at the location and I had a view of a unpopular, politically incorrect subject.
So you did not obstruct
No.
anyone coming or going?
In no way.
Neither patient nor employee?
That's correct.
But they charged you with the same and then took you to trial and you were convicted, was it by jury?
Correct.
All right, I got a better idea then of what's going on here. And I need to understand my special agent, former special agent. All right, you were based where at the time of your dismissal?
Daytona Beach, Florida.
And at the time, you were part of the investigations for January 6th. Did I hear that?
Some of the investigations I was involved in, yes.
And you were participating in the strategies and gathering evidence and all that?
On paper, yes, which was one of my objections to the way that those cases are being departing from the way that they're supposed to be managed. Our names in our office were as the case agents that were running those cases, but we were actually taking directives from Washington, D.C., where there's a task force set up specifically for January 6th, and they were dictating what we were supposed to do on our own cases. And one of my concerns about that was, well, we're not making these decisions. We're the case agents. If we have to go and testify at trial about the facts of this case, we're not going to be in a position to do that. And I thought that if it's a righteous investigation, it's a righteous prosecution, could actually jeopardize a conviction.
So were you part of the charging mechanism that you make recommendations for charges on the January 6th conspirators?
We should have, because they were our cases, but we actually weren't. The affiance on those, because the alleged offenses happened in Washington, D.C., agents in Washington, D.C. would be the affiance on the arrest warrants for those arrests.
Mhm.
And then if there was going to be a search warrant for the person because they resided in our area, we would be the affiance on that because we would need to get a magistrate in our area to sign because of the location would be in Daytona's area.
All right, so you said you are labeled as a whistleblower. Is that self-titled or is that the declaration from the courts or?
There's no declaration for that. The law is 5 U.S. Code 2303. Essentially says if you may have a reasonable concern of waste, fraud, abuse, or a risk to the public safety, and you bring those concerns to a list of specific people, that you are entitled to whistleblower protection against adverse actions. The list includes frontline supervisor, anyone within your chain of command, members of United States Congress, the Office of the Special Counsel, the Office of the Inspector General, and I brought all my disclosures actually written to Congress, to the Special Counsel, to the Inspector General. I made out loud, verbalized complaints to my frontline supervisors.
So who says that you're a whistleblower besides yourself? Does the statute include some official pathway to you being declared a whistleblower?
There's
does
no,
that
there's not like a legal like declaration where that happens. It's just, or did you comply with the law? And the Inspector General has taken my complaint and they're working on it.
Okay, then I'm still not clear on all of that. But the other thing I want to try to understand, you made reference to domestic violent extremists a few times. So I'm trying to figure out who they are and how they're connected to this law as amended, to this bill as amended.
The case I've made about domestic violent extremism is it's a particular category, a subcategory of what the FBI lays out as potential terrorists. Under domestic terrorism, domestic violent extremism is a subcategory. And they have a profile of what meets that, and as well as they have other profiles around. That's what I'm bringing to your attention. The issue as it comes to the amendment to this bill is the fact that someone who represents a local law enforcement agency is working with the FBI and not now responding, not able to tell his actual elected supervisor, the sheriff who he's supposed to be accountable to, he can't tell him what he's working on is something that this amendment would then change that ability, because it would incentivize the FBI to bring a legitimate case to the sheriff because he has a need to know. And then he could himself work it. He could find deputies to work it, and they could partner with the FBI. The issue is just changing the order of things, because if you up front take someone and make them a task force officer and assign them to things, they're not accountable to their true person who's supposed to have oversight of them.
Okay, so the sheriff makes the determination on whether one of his deputies is going to work with FBI. Is that correct?
Are you asking as it currently is, or what the bill is going to say?
As it currently is.
As it currently is, the sheriff can nominate someone to become a task force officer. He doesn't have say over what cases he works at the FBI.
Okay, so if the sheriff is not happy with it, he can pull the deputy off, right?
If he's not happy, he can pull him off. The question then is, if he doesn't know what he's working on, how can he actually make a determination whether or not he's happy with the work that's being done?
Okay, I'm not sure about those task force, except for the elected officials that I've been associated with. And I've never known the sheriff to feel like he or she has been shut out. And of course, I'm not going to discuss details, but if the sheriff was displeased with how the task force is proceeding in any way, shape, or form, then the sheriff would recall his man or woman back in off of the task force. So I don't understand that logic that the sheriff would be locked out of knowing what the deputy is doing, and then be in a position of where he or she, the sheriff, would not be able to manage it to his or her people. The other thing that you referenced was racist supremacists. Tell me how this relates, this bill as amended would relate to the prosecution, the investigation of racist supremacists / extremists.
The category is racially motivated violent extremists. That's the subcategory of domestic terrorism. Ergo, the FBI can investigate that as a factor as a example of domestic terrorism. Could open up an assessment, do a preliminary investigation, do a full investigation of an individual who met that descriptor. Now, the point what I'm bringing up is the definition for that is incredibly broad and encompasses things that are First Amendment protected activities.
Okay, I'm not sure where that's going, Mr. Chairman. I'm not going to get into the weeds on a lot of stuff, but if I've got to try to err on the side of whether I make a terrorist uncomfortable versus stopping that terrorist from carrying out an activity and a violent activity, I want to err on the side of making that terrorist uncomfortable. And I'm getting a sense from you that you would err on the side of, on the other side. I'll just put it like that. I don't want to put words in your mouth.
All right.
But unless
I-
I'm not
I-
asking a question, but if you want to
The
respond.
FBI has a
fine.
caveat that it doesn't investigate your First Amendment speech and right to worship. But the way that they're understanding their national security mandate, they're able to circumvent that. That's my contention.
All right, I appreciate the FBI. I know they've got some flaws, and I track flaws all the way back to the modern civil rights movement. And I know they've got flaws, but if I've got to look at whether I like to live with them or without them, I want to live with them. They've done a lot, in my estimation, on protecting this country from terrorism, and that's domestic and foreign. And I've certainly seen firsthand how they've been able to assist in getting civil rights for Black folks in particular enforced in this country. So I thank you for your testimony. I disagree with you on a lot of stuff. And to the other gentleman, I'm not sure how you fit into this. I think what you related, and just a little quick research
I can give
said,
you one sentence. The issue is not proposed terrorist to a terrorist act. The issue is terrorist to actual citizens executing and operating within the First Amendment area. That's the distinction, not making terrorists uncomfortable and terrorists doing terrorist acts. The issue is terrorism versus American citizens having the rights. that we
okay,
have and
I
enjoy.
would disagree with you on what
Well, that's my
the
experience.
issues are as I see them. And when I looked and saw that you were accused of obstructing access for patients and obstructing the ability for employees to do their job at the clinic, it takes away some of your credibility. But I appreciate you being here, and thank you
I'll come to your
for
office and show you
engaging.
the tape someday. We can
Thank you,
discuss.
Mr. Chairman.
Yes, sir. Thank you. Representative Russell, the final question right here, briefly, please.
Thank you. Just briefly, and this is to Mr. Friend. During your time as an agent, did you work with any of these local task force agents?
Yes.
And do you have firsthand knowledge of what this bill will protect against?
Yes, I do. What I was articulating before, they would, the FBI, if they have intelligence or reason to believe that someone is engaging in activities that are terrorist in nature, could bring those concerns directly to the chief lawman at a particular agency where he has that knowledge, would make sure that he's informed of that. And then that sheriff, police chief could make a determination for how to partner with the FBI, as opposed to co-opting one of their individuals and assigning them to things without the sheriff's knowledge of it. And I can tell you, having been on a joint terrorism task force and working with some task force officers, they're very experienced, they're very capable, they're more capable than most FBI agents that I had a chance to work with. But unfortunately, they're at the beck and call of what the FBI tells them to do. And I've more than once heard them mutter that they knew what they were doing was wrong, but they had to do it.
Very good. I make the motion, we go back in session.
Thank
Thank you.
you. We will go back into session. Thank you for being with us today in your testimony. We're back on the amendment. Amendment code is 15675. It has not been adopted yet. It is in the proper posture. Do you want to explain the amendment, Representative? All right, go ahead.
Thank you, Mr. Chairman, and thank you again for your patience. Let me first start by explaining what this bill will not do. This bill will not prevent any officer from working on other FBI task force focusing on criminal investigation. This bill will not prevent any officer from sharing intelligence with the FBI. This bill will not prevent an officer from partnering with the FBI on any other agency to investigate terrorism in Tennessee. This bill will require FBI to bring a legitimate counterterrorism threat directly to the folks that we elect, our sheriffs, before they recruit their officers and take them away from local crime and put them on something else. That's all this bill is seeking to do, is to get the sheriff's permission and the sheriff to be involved. And that's what this bill does, and I stand for questions there, Mr. Chairman.
All right, any questions on the amendment? Leader Lambert.
Thank you. On the amendment, and it's a very brief amendment, I appreciate the fact that we had time between earlier today and now to actually have a copy before us. It says the nominee is limited to matters involving Title 18 and 21 of the United States Code and must only engage in relevant law enforcement activities pertaining to violation of criminal law. Then it goes on to talk about the nominee shall not assist the FBI in national security investigations or operations. Further, the nominee must not be a member of the FBI Joint Terrorism Task Force. I read that because here's my question. We have 6 million people that have streamed over the border in the southern part of the United States, and this amendment says that local law enforcement can't cooperate or be on a joint terrorism task force. That gives me great pause. I understand what these gentlemen have testified to. I get that that's their experience. But to just say you can't participate in a joint terrorism task force when any sheriff can pull their people anytime they want to, if they feel like they're being inappropriately utilized, gives me great concern. What would you say to that, sir?
What I would say to that is that I want our law enforcement to protect us at all means, whatever it takes. If it takes working with the federal government, that's what I want them to do. What I don't want our law enforcement to do is to be recruited to go down here and attack Granny from going to the school board meeting down the street, and we spend our law enforcement, time investigating someone or some mother that's upset at the school board, or someone that's going to the Catholic Church. I don't want us taking our law enforcement and going after those people that have done nothing wrong and looking for a crime instead of having a crime committed and then investigating. But I'm all for law enforcement helping the federal government. And if you go down and you read paragraph C in this bill, this section does not prohibit the direct sharing of information for investigative purposes or participation in fusion centers. So it allows them to work back and forth. The idea that we want to stop our local law enforcement agencies from working with the FBI is just not true.
I understand that, and with all due respect, that's a great speech. But the words on the page is the nominee shall not assist the FBI in national security investigations or operations. And further, the nominee must not be a member of the FBI Joint Terrorism Task Force. Now, I've talked to my local law enforcement folks. If any of their people are assigned to a Joint Terrorism Task Force and they are not being utilized exactly in the way that they've agreed to, they are locally hired, they are locally allowed to be on that, and they can be pulled back at any time. I just have concerns because I lived through 9/11. I remember those days vividly. I don't want the federal government to go out there too far on these things, but I deeply want our communities to be safe and our rights to be respected and preserved. And to just have, those two sentences say shall not and must not. Those are strong words, and it leaves no wiggle room. So I just have concerns. I just wanted to bring that up and wanted to hear your response, and I deeply appreciate it. Thank you.
Representative Howell.
Thank you, Mr. Chairman. We've heard some compelling testimony, but I think in order to do our due diligence as a committee, I would like to have an understanding of why the TBI and the Department of Safety are flagged on this bill and oppose it. That might help us as a committee make a better decision.
I think it's past their working hours.
Mr. Chairman, I might ask the sponsor if you can shed some light on why they're opposed to it.
Yeah, we tried to work with and I'll let them testify to that. We added this last paragraph. I hear all the time when we pass bills out of committee that what the intent of the legislation is. We told you what the intent, and we get that on the record all the time. But the intent of this legislation is not to prohibit law enforcement from working on serious cases. It's this kind of stuff that I pointed out to the leader, and to stop the frivolous investigations going on.
Representative, would you like to hear from TBI? or Department of Safety?
I noticed that Colonel Perry and the representative from Department of Safety are all here in the room. I'm at the will of committee, Chairman.
Okay. Without objection, we'll go out of session, hear from Department of Safety and TBI. If you will, introduce yourself for the record. You'll have 3 minutes for comments.
Elizabeth Stroker, Legislative Director for the Department of Safety, and I'll be brief and turn it over to Colonel Perry. With all due respect to the sponsor and the witnesses, the issues that they brought up actually are not rectified by this bill. This bill simply would prohibit state law enforcement agencies from partnering with our federal partners. They would still be able to do all of the things that have been mentioned so far. And I'll let Colonel Perry talk to our partnership with the feds and how this could actually hinder law enforcement's ability to investigate and prosecute serious crimes.
Colonel Matt Perry, Tennessee Highway Patrol. Thank you for the opportunity to speak. As Director Stroker said, with all due respect, I'm kind of I'm 100% in agreement with Leader Lambert. This bill to us stops a trooper. We have troopers assigned to JTTF from taking part, from being a member of JTTF, taking part in those investigations. And those are local investigations. They are terrorism related, but they are local to Tennessee. Everything that the witnesses spoke to would not be resolved, as I don't believe it was a JTTF case that he spoke to in terms of the one that happened in Tennessee. Our trooper was not assigned to that case. In terms of working with the FBI and information sharing, that they have been, in my experience, a good partner, and they talked about need to know. Certainly I don't need to know everything, but they tell us about things. We've never felt like we were left out of a conversation. They regularly have law enforcement executive meetings for those with the clearance, as I have, to come in and be, briefed on those investigations that pertain to Tennessee, and certainly that troopers are helping investigate.
Patrick Powell, Policy Director with TBI. Echo the statements made by Safety. Leader Lambert hit the nail on the head. This would prevent us from cooperating with feds on a number of issues. Director has actually pushed for more participation on task forces, whether it be drugs, joint terrorism, whatever, so that we have a voice and so that we have personnel that we trust that are seeing these issues. And for those reasons, we are opposed to the bill.
All right, Chairman Halsey.
Thank you. Appreciate you being here. Colonel, my experience is local law enforcement did all the work and the Bureau took all the credit. It's the way it usually worked out. At the end of the day, though, you would never want one of the men on your command to take a man like that back there under that kind of conspiracy charge or have anything to do it and put him in jail and let him face a 15-year sentence. I mean, that wouldn't be what you would be looking at working at. And I thought that was the purpose of this bill, is to stop that kind of cooperation in terrorist labeled issues that turn around and arrest school board members or somebody like this gentleman back there.
All right, we're not going to have comments from the audience, okay? All right, continue.
That's what I thought the bill was trying to fix, not to keep you from cooperating with the FBI when they've got some big drug cartel rolling through here that they're working on, or cases like that.
I can't speak specifically to that case, other than there wasn't JTTF local law enforcement involvement in that case. That was just an FBI case. This bill won't stop the FBI from investigating cases like that. Certainly, we would never want anybody who's not committed a crime to be.
Exactly. Thank you.
Yes.
Representative Gillespie.
Thank you, Mr. Chairman. I'm not sure who to direct this to, but I know in the last 6 months or so, the city of Memphis has gotten a significant amount of help from the Department of Justice. I know that we have I guess I could say this. I know that we do have a fusion center in Memphis, and that there's been a lot of all hands on deck effort to come in and help us. And it is my understanding that a lot of those efforts would no longer be, at least with the MPD and other local entities, would no longer be allowed to be in assistance with that influx of DOJ personnel. Can y'all speak to that?
As far as kind of the assistance that the feds have given Memphis, I don't know that it would necessarily impact. Obviously, this is limited to joint terrorism task forces and the prohibition there. So obviously, anything that falls in that vein, it would prevent. It doesn't prevent necessarily drug task forces, but it depending on the circumstances, obviously could prevent a number of things with local law enforcement, TBI, safety, Homeland Security from participating. And that obviously gives us a great deal of concern.
Representative Hardaway.
Thank you, Mr. Chairman. Good afternoon. Anybody can take this question. Is it past your work time?
Yes,
No,
sir.
Okay. All right. Thank you, Colonel. For you, Colonel Perry, I can't believe that you would even agree to participate in a joint task force if you didn't know enough on the front end already and have access to information. And I would think there's nobody that needs to know more so than you. So can you help me with this need to know bit where your nominees or those that you're allowed to participate would need to know more than you need to know?
Yes, sir. I appreciate that. Colonel Matt Perry, Tennessee Highway Patrol. So the need to know is kind of a distinction, like the witness said, that if you have a clearance and it's a case relating to certainly something a trooper is involved in, and it gets to the point. I mean, there's investigations that troopers are conducting right now in our CID and other that I don't know what's going on right now because they're investigating. But at the time it becomes relevant to me in my position and making decisions or a big, maybe arrest is going to be made. That's when. But I know I can pick up the phone and call, and they'll tell me what they'll give me an update on a case, on my troopers' involvement, so that there's never that communication, barrier. We've had a great relationship with all of our federal partners, to include the FBI. I'm like Director Roush. I would like, more troopers because it's information sharing, it's working together. We all have common problems, whether it's, I say Memphis to Mountain City. We all have expertise in certain areas and need to work together. And that's what this does to pull us out of that. The FBI would have no real need to communicate with us other than those really last minute, hey, we need a trooper for help. So this helps build a relationship, bridge as well.
All right. And I said I would keep it brief. So, Mr. Chairman, I'm going to just leave with one declaration. We need more troopers, and troopers need more pay.
All right, Representative Fritz.
Thank you, Mr. Chairman. I'll be really quick too. This goes maybe outside the topic of this conversation just a little bit, so I'll ask for the chairman's patience. So Congress has oversight authority over those federal agents, and they have clearance levels that are issued to the U.S. Congress, so that they do have a need to know to have those conversations because they're funding and legislating to appropriate, for what the FBI does. So should we have that in the state of Tennessee, since the state of Tennessee pays the salaries of you and all these other uniformed men that we have here tonight? should we have that same need to know, or some portion of us, so that the people who elected us, maybe not all of us, but would have access to that need to know information? What are your thoughts on that, Colonel?
Well, I'm, not having, thought about this thought. I mean, there's definitely a situation. I've met with members this session who certain things have happened in areas that they wanted to know what was going on. And we want to share. We want to be careful to protect the integrity of an investigation, or certainly the safety of people, so information doesn't get relayed out. But we are pretty much an open book and believe in that. So I would say that some form of what you're talking about probably should be in place.
Thank you so much. I think, having had a federal clearance for a long time,
Yes, sir.
I think there's probably federal penalties that, for sharing information that the recipient does not have the need to know authorized, that would require prison time. And so if that is the case, if my memory serves me correctly, then certainly if we are working joint task force where there is a clearance, maybe this body needs to think about establishing a clearance on this body so the people have an elected voice to understand what's happening.
All right. Any other questions for our guest? Seeing none. Thank you for your time and testimony. We're going back into session. All right. We are still on Amendment Code 15675. Any questions for the sponsor? Yes, sir, Representative.
Thank you, Mr. Chairman. And I know there's been several good questions raised here and concern. And again, I think you understand where I was coming from or what the intent is of the legislation. Is there a chance that we could work with the Department of Safety? Do we have time on the calendar this year to roll this to the Hill and maybe get this in proper language that would suit to the leader and maybe some of the other members of the committee?
We are on our last calendar. If it was to be rolled to the Hill, I would anticipate that we would be back in here again next Tuesday for a regular meeting. We're not going to conclude the calendar tonight for sure. So we will have at least one more meeting. As a motion is seconded, any objection? Seeing none, House Bill 2912, roll to the Hill.
Thank you, sir. Thank you, committee.
Yes, sir. Item number 53. House Bill 2301 by Representative Howe. You are recognized.
Thank you, Mr. Chairman. This bill deals with the sale of fentanyl or any derivative or mixture of that.
Representative, I'm sorry, there are two amendments here. I don't know.
I have one, which I believe the correct one is 17327, sir.
Amendment Code 17327.
That's correct.
All right, you're recognized on the amendment.
All right, the amendment makes the bill.
Okay, you want to go ahead and adopt? Question's been called on the amendment. Any objections? Seeing none, we're voting to adopt Amendment Code 173-270. All those in favor say aye. Aye. Those opposed? Ayes prevail. We adopt. We're on House Bill 2301 as
Chairman,
amended.
just for clarity, could you repeat the code that you just adopted?
17327.
Correct.
Zero. Okay, there is no zero at the end of it.
That's why I asked. Thank you. Members, the current criminal code in 3913-210 allows a district attorney to charge a drug dealer with second-degree murder when an overdose occurs, and they're doing that now under the criminal code, the one I just quoted to you. However, traditionally, juries perceive second-degree murder as the knowing and willing killing of another person with something like a gun or a knife. According to the DAs that I have spoken to regarding this bill, many times juries do not perceive the selling of fentanyl and the resultant overdose as a homicide. So what this bill does is simply take the language in the section of that criminal code, 3913-210, and puts it in the drug code section 3917-417, which addresses the selling of drugs, and adds the criminal code language to the drug code language, and it will make the prosecution of a dealer who sells fentanyl resulting in a death much less confusing to a jury, with a cleaner prosecution, and the DA has more discretion to charge a dealer with second-degree murder under the drug code. And that's the best I can explain it. Mr. Chairman, stand for questions.
All right, any questions for the sponsor? Seeing none, we're now voting to send House Bill 2301 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward. Item number 17, House Bill 2790 by Representative Littleton. You are recognized. You do have an amendment code 14346. Do you wish to proceed with that?
On 2790?
Yes, ma'am.
No, 15108.
Wait a minute. I'm sorry. Now we're on 2790. Will you repeat that amendment code?
15108.
Oh, there it is. Okay.
Got it?
The amendment code is 15108. All right, you're recognized on the amendment.
Thank you, Mr. Chairman. This bill as amended clarifies that an existing Class B misdemeanor offense for knowingly tampering with, removing, or vandalizing a monitoring device ordered as a condition of bond applies to all alternative monitoring devices as ordered, creates a Class B misdemeanor offense for a person released on probation or parole to tamper with such monitoring devices or for a person to aid, abet, or assist the offender in such tampering. Establishes that if a person ordered to wear the GPS device tampers with the device to the extent that the device is damaged, the offense may be punished with a Class A misdemeanor offense for theft. Requires an entity monitoring such device that becomes aware of such tampering to promptly give notice of the violation to the probation officer or the Department of Corrections.
All right, any questions for the sponsor on the amendment? Representative Johnson.
Now, is this one 2790? I want to make sure. I thought that's what I
Yes,
heard.
ma'am.
Okay. So the concern I have, I know it does say knowingly here, and I know that I'm tampering with this device. Saying a mom or grandmother is trying to help fix or adjust the device and something goes wrong with that device. That was a situation that's actually come up a few times where there's a problem with the device. Someone in the family tries to help them with the device and it gets off track. Is there anything in this legislation that's going to, help those folks that might have just been trying to make the situation better and it messed it up or something?
I don't think so.
So if grandmother or mom was just trying to help with the device and it caused a problem, they were knowingly helping, but they weren't intentionally trying to sabotage the device. So
What type of problem? If they're just trying to adjust it, it's not going to break and it won't seem that it's been damaged.
well, apparently that has happened. And so I was just wondering if there was any kind of language addressing, because in a way you think knowingly might handle it, but then again, there's also the intent behind it.
I guess that would be up to the judge to just make that decision.
Any follow-up?
No.
Okay, thank you. Leader Lambert.
Just want to make sure in the amendment that we have changed all the penalties in this to match with some of the other bills that we passed through, that they would all be an A misdemeanor. And I think that's what you mentioned. I just want to make sure that it's A misdemeanor throughout. Is that accurate now?
Yes, it is.
All right. Thank you, Chairman.
All right. Any other questions on the amendment? Seeing none, we're voting to attach amendment code 15108 on the House Bill 2790. All those in favor say aye. Those opposed? The ayes prevail. You adopt or on House Bill 2790 as amended. Any questions for the sponsor? Representative Hardaway.
Thank you, Chairman, and thank you, Chair Lady, for the bill. Would this treat domestic violence related cases any differently?
No.
All right. I'm of the firm belief that if you are required to wear a GPS and it's related to domestic violence or sexual assault or something, if you tamper in, it ought to be a felony. So I thank you for the bill. I wish it was more severe for those guys that are trying to get loose and do more damage than they're already accused of. Thank you, ma'am.
Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2790 as amended to full criminal. All those in favor say aye. Those opposed? Ayes prevail. You move forward.
Thank you, Mr. Chairman and committee.
Thank you. Item number 21, House Bill 2471 by Representative Raper. You are recognized.
Thank you, Mr. Chair.
You have an amendment code 15109. Do you wish to proceed with that amendment?
I do, and also have another one. 016771.
I don't have that amendment. Repeat that number one more time, please.
016771.
Okay, we don't have that amendment in our stack here. We don't have that amendment. The only amendment we have is 15109.
Okay, I'm at the mercy. What would be the discretion of the chairman? Should I run it without it?
I'll tell you what we'll do. We'll roll you. Is it substantially changed what you're attempting to do?
No, it's an agreement I had at the sheriff's department and
About the custody?
Yes, about room as far as the prison's concerned.
Okay. Do you need amendment code 15109 on your bill?
I do, yes, sir.
Okay. All right, you're recognized on that. Do you wish to adopt that amendment or you want to explain it first?
Please adopt.
Okay. Without objection, we're voting to add amendment code 15109 on the House Bill 2471. All those in favor say aye. Those opposed? The ayes prevail. You adopt. We're now on House Bill 2471 as amended. You're recognized.
Thank you, Mr. Chair. The purpose of this bill is to give latitude for judges to transfer 16 and 17-year-olds to adult court under certain conditions. Those conditions are juveniles must be 16 or 17 years of age. They must be juveniles with the second or more offense of criminal gang activity. And criminal gang activity is defined by TCA 40-35-121. And the juvenile judge still has a prerogative, even under that, if they want to keep them in juvenile court. So this is not a shall statement. It's a may statement. So it will allow them. And I will conclude saying this. There is no one more suited to know the background to treat youth as children when appropriate, knowing interventions and services rendered that have already been put in place and the opportunities that have been given and making the best decisions that would be appropriate for the rehabilitation of a child. Finally, when the rehabilitation is not successful, we must put our trust in our judicial system when to transfer a child. So I open the floor for questions.
Questions for the sponsor. Representative Hardaway.
Thank you, Chairman. And what will this change from the current statute to your bill? What will change as far as who's eligible for transfer and the judicial discretion?
Thank you for the question. most of the things that that are already in law, and that they will automatically be transferred, but there will be some more of misdemeanor crimes that will not. But if they have two or more, and then if the judge's prerogative that they see that the rehabilitation is not going well, then and they know the background history, of course, and everything, at that point, then they will have the prerogative to transfer them to adult court. And I know that this amendment was on there, but also that will. When I get this attached, this other amendment, it will be only if there's room in adult court. So it's not an automatic. It will only be if there's room there. So.
Okay, I guess what I'm trying to get at is whether we're creating a new class of juveniles who can be transferred, or what's different. And maybe if it's a confusing question that I'm posing, perhaps we can go out of session and engage our legal counsel.
Yes, sir. I'm more than willing to do that. Yes. Yeah. I think he's requested to go out and ask legal.
You asking to go out to see legal services representative?
Yes, sir. Somebody's smarter than me.
All right, we'll go out of session. Hear from legal service.
Michelle Fogarty, Legal Services. Could you repeat the question, please?
Yes, ma'am. I'm trying to see what the difference is for the age and the perhaps the charges that of juveniles, those who are eligible now versus those who will be eligible. Are we creating a whole new different class, or are we changing the criteria for transfer? Is judicial discretion limited more with this bill than at the present, under present statutes?
It does not do anything in regards to, it's still, any transfer would still be within the discretion of the court. It adds in regard to juveniles who are 16 and up, which offenses for which they may be transferred. And according to the language in the bill, it's a second or subsequent criminal gang offense. And criminal gang offenses are defined as first-degree murder, second-degree murder, voluntary manslaughter, assault, aggravated assault, kidnapping, especially aggravated kidnapping, robbery, especially aggravated robbery, carjacking, rape, rape of a child, aggravated burglary, especially aggravated burglary, aggravated criminal trespass, coercion of a witness, retaliation for past action, riot, aggravated riot, inciting to riot, the illegal sale, delivery, or manufacture of a controlled substance, possession of a controlled substance, unlawful carrying or possession of a weapon, and trafficking for commercial sex acts. Some of those offenses are already eligible to be transferred for juveniles who are 14 and up, and some of them are not currently eligible for transfer, but would be upon a second or subsequent offense if this bill were to pass.
And would that age be 14 and up or 16 and up?
Under the bill, it's 16 and up.
Okay. Thank you, ma'am.
You're welcome.
Any other questions for legal services? Seeing none, we're going back into session. Representative Hardaway, you got any follow-up?
No, sir. I'm ready to vote that bill out.
All righty, Representative Johnson.
Thank you, Mr. Chair. One concern that was brought up to me is that the definition of a gang is pretty broad in the statute. It could be 3 teenagers with the same football jersey on, or, three kids on a sports team. So I do see that there is judicial discretion, and that helps some. But do you think that's going to be a problem at all with that broad definition?
I don't, Representative Johnson, and I'll go to the last statement I made. I think that at some point we have to put trust in our judicial system, especially someone that advocates for children all the time. And I know there are bad apples that people can point out, but I think that we need to concentrate on getting rid of those instead of good legislation that may target getting gang activity under control. And I'm hoping with this legislation that we can start targeting things earlier and trying to stem off getting to the point of 16, 17-year-olds possibly being moved and transferred to a juvenile court.
And thank you. And maybe who knows on the line really defining what a gang looks like.
Any other questions for the sponsor? I will say that if this law was enacted, this bill, it would seem that these juvenile judges would have had an opportunity to see these youth before this would ever have an opportunity to be triggered. And so hopefully they would be educating these youth the first time that they come in, that if they don't make some better choices, they may end up finding themselves in a more stickier predicament.
And I'd said earlier, Mr. Chair, that there's no one that is going to know the history and background better as far as criminal activity than the actual juvenile judge. So yes, you're exactly right.
Representative Hardaway, briefly.
Thank you, Mr. Chairman. And I agree with you that nobody else is suited with the professional knowledge and background and experience as the juvenile judges and the juvenile court staff. What I wanted to make sure that we got out, even though at times you're saying gang activity, you are using that interchangeably with criminal gang activity, and criminal gang activity is what this is all about.
Yes, sir. That is correct.
Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2471 as amended on full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward. All right, let's go to item 22, House Bill 2475 by Representative Raper. You are recognized. There is an amendment code here, 14597. You wish to proceed with that?
Yes, sir.
All right, you're recognized on the amendment.
Okay. Yes, as far as, would you mind just attaching that, please?
Okay. Without objection, we'll vote now to adopt Amendment Code 14597 on the House Bill 2475. Those in favor say aye. Aye. Those opposed? Ayes prevail. We adopt on 2475 as amended.
Thank you, Mr. Chair. This bill pertains to truancy in juvenile court. The court has already filed an unruly at this point for excessive truancy. Many of these students provide a large number of medical release forms, doctor's notes, in other words, which a school must accept based on current law. In many of these situations, the court would like more information. And I've heard, being an educator, I've heard of bogus notes that a receptionist may write and different things like that. So they want to obtain more information to see if there's legitimacy behind this. So upon the request of the teen court, or as we call in our area, campus court, the doctors will be required to provide the requested information. And this bill will assist principals, assistant principals on obtaining pertinent information about chronic absenteeism, which they currently cannot do because they'd be violating the HIPAA law. But if it stayed in teen court, then those that are reacting in teen court, they do not have to tell the assistant principal or the principal anything. They can keep it right there, but they can obtain more information as a request request, it will be accomplished without adding any additional burden to a juvenile judge, which previously has only been accomplished by a subpoena. This bill will possibly correct many chronic absentee issues by being solved through teen court before ever reaching a juvenile judge. So at this point, I'll open the floor for questions.
Any questions on the bill? Representative Johnson.
So with the amendment, it's actually getting the information from a physician, not additional information from a parent.
That is correct.
And it is understood that this information is going nowhere but to the court.
To the court, not even to principal or assistant principal. They can't violate the HIPAA law either, so it stays right there.
Thank you.
All right, Leader Lamberth.
Move previous question.
All right, previous questions called. Any objection? Seeing none, we're voting to send House Bill 2475 as amended to full criminal. All those in favor say aye. Those opposed? Ayes prevail. You move forward. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chair and committee.
Item number 23, House Bill 2667 by Representative Raper. Representative Raper. You have one more, 2667. You wish to proceed?
I took that one off notice.
Without objection, House Bill 2667 is off notice.
Thank you, sir.
Easy enough. All righty. House Bill, let's go to item 25, House Bill 1827. Representative Martin. All right. There's an amendment code 14156. Do you wish to proceed with that amendment?
Yes, sir.
All right, you're recognized on the amendment. Does the amendment make the bill?
Yes, it does, sir.
All right, let's go ahead and adopt that. All those in favor of amendment code 14156, going on to House Bill 1827, say aye. Those opposed? The ayes prevail. We're on 1827 as amended.
Thank you, committee and chair. This bill was brought to me from a senator out in East Tennessee, but after speaking with several of my judges as well in West Tennessee, they like the bill. So currently the threshold to obtain a juvenile runaway is 24 hours. East Tennessee has been experiencing juvenile drug overdose and abuse. So at times these runaways were coming back into custody, still detoxing. Few rare instances where juveniles had gone into transitional homes were needing extra care that could have been provided at that juvenile detention center had it been caught earlier. Juvenile courts have requested in extreme circumstances to be able to hold these individuals up to 72 hours. And it's important that we trust the juvenile judges in this process when needed under these rare circumstances. With that, I stand ready for question.
All right, first on my list is Representative Johnson.
Thank you, Mr. Chair. So one of the concerns I'm hearing about this legislation is that it's risking $1 million in funding from TCCY due to the federal regulations of how long you can hold a juvenile. And so this would take us outside of that. And there are $1 million that come into Tennessee for prevention that go to some, to work alongside and through this. So what do you know about this threatening that $1 million?
Yes. Thank you, Representative. Yes, that was the part that was added in on the amendment after TCCY got involved to help out with the conversation. So currently in Tennessee, the Juvenile Justice Delinquency Prevention Act says you can only hold them for 24 hours. There are situations where it can go over that. Currently, that $1 million funding is tied into that portion if we fall within that care. So depending on how many times the provision is used, that federal funding could be risked. But what that would do, what the amendment does is say they use it in only rare circumstances, extremely rare circumstances up to the judge. And currently in Tennessee, we've had about half under that threshold of compliance over the last few years already. So we're already well below that threshold of what it would have to be to risk that.
Okay, but there still may be some risk. Potentially.
Potentially, there could be some risk.
Thank you.
Yeah, the questions, Representative Davis.
Thank you. And to the sponsor, so how would that judge know how many times it had been used or not used to potentially be able to determine whether or not they can use it to not risk that funding?
Thank you, Chairman. I do not have that answer on exactly how they would keep up with that portion of it.
Okay.
I was just told it's under that threshold, or has been consistently under that threshold of what we've done. So
Okay, thank you.
I can find that out for you, however.
Any other questions for the sponsor? Seeing none, we're voting to send House Bill 1827 as amended on the full criminal. All those in favor say aye. Those opposed? The ayes prevail. You move forward. If you wish to be recorded as a no, please see the clerk.
Thank you, committee and chair.
All righty, item 27, House Bill 2460 by Representative Vital. You are recognized. There are no amendments. Or are they? No.
This is a pretty simple bill. Thank you, Mr. Chairman,
Yes,
committee. House Bill 2460 is brought to me on behalf of the Electric Co-op Association. This legislation seeks to amend existing laws to allow cooperatively owned insurance companies to pursue restitution from convicted persons who have harmed their subscribers, which are the local cooperatives. The need for this change arose out of a court decision where a judge determined the court did not have the authority to award restitution to a reciprocal insurance company, highlighting a gap in the current legal framework. The proposed legislation will allow us to work with the insurance companies to collect restitution and protect the financial interest of the electric co-op. This legislation promotes fairness, enhances legal clarity, and strengthens the ability of the reciprocal insurers to fulfill their mission. With that explanation, I am happy to answer any questions.
Thank you very much for that. Representative Johnson, question.
Thank you. I guess, again, the concern here is that this changes what the term victim means. And typically restitution is paid to the victim, but we're talking about paying restitution to who?
Thank you, Mr. Chairman. In answer to your question, the victim here is the cooperative association that insures our cooperatives. They are defrauding ultimately the consumers who own the association through the electric co-op.
Okay, thank you.
Any other questions? Representative Holsey, Chairman Holsey.
I'm assuming that the judge would have awarded had he had the ability to do so were the law written correctly.
That is correct, Mr. Chairman.
All right. Any other questions? Seeing none, we're voting to send House Bill 2460 on the full criminal. All those in favor say aye. Those opposed? The ayes prevail.
Thank you,
You
Mr.
move
Chairman.
forward.
Thank you, committee.
All right. I know you are, but we still got work to do here. Item 29, House Bill 2820 by Leader Camper. You are recognized. There are no amendments.
Thank you, Mr. Chairman and committee. Mr. Chairman, committee, what this bill does, it requires a supplemental adjustment of state funds to public defenders' offices within Shelby and Davidson County for the purposes of establishing pay parity. Right now, what we have in our two counties is our public defenders are funded differently than the state funded positions. So you could have a public defender state funded with 7 years of experience, making more than a county public defender sitting right next to him, 15 years of experience. And so what we're trying to do is get pay parity here with the public defenders within Davidson and Shelby County. The code established salaries different for those two counties because they are outside of the public defenders conference. And so most of, if not all of the funding is rested upon the county governments and not the state. And so what we want to do is bring parity to those two. And with that, I'll take questions, Mr. Chairman and committee.
Well, thank you for that explanation. Leader Lambert.
Move previous question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 2820 on the full criminal. All those in favor say aye. Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chairman and committee.
Let's go to item number 32.
Mr. Chairman, we'll take that one off notice.
Okay,
If
without
that's all right
objection,
with the
or
committee?
that's 2832. Is that the one you wish to
I
take?
have 2821 is
Okay.
what I have, item 30.
We've already taken off
Oh, you're
28,
okay.
21 earlier today. Yes,
Okay,
ma'am.
all right. And so,
We'll go to item 32, which is House Bill 2832.
yes. Thank you, Mr. Chairman. So, Mr. Chairman and committee, can I get a motion second on that? Oh, I
Very
did.
good.
Okay.
All right, you are
Thank
recognized.
All right, thank you, Mr. Chairman. Mr. Chairman and committee, what this bill does is it authorizes an inmate to request a review of their incarcerated sentence by a court of competent jurisdiction with proof of an extraordinary and compelling circumstance, including non-retroactive changes to the law. It could be some serious medical conditions or the fact that the inmate was sentenced as a juvenile. The courts will have the authority to give a second chance to those that who have been deemed extraordinary and compelling with their circumstance to have their and may not have been relevant during the initial sentencing. So it will serve as an opportunity to encourage this person to get rehabilitated, to if they could get sentence reduction. It will also help lower the crowding that's in our jails right now and give people the opportunity to, with the sentence reduction, to be released versus being on a long sentence of parole. So that's what it does.
All right. We do have someone here to testify on this. Or
Yes.
their name's on the list. Dawn Harrington. Does that sound right? Nope.
He's not here.
Okay.
It's
Well,
all right.
That's fine. Maybe next time. Leader Lambert.
Thank you, Mr. Chairman. Leader, I know we've talked about this beforehand, but I just want to say publicly my concerns here. This is brutal for victims and survivors of crimes. I mean, to pull them back and forth into the court system. The parole hearings are bad enough. You know my perspective on this. It ought to be truth in sentencing where you get a sentence and then that's your sentence, because quite frankly, it's horrible on both the victims and survivors' families as well as the defendants' families, because it's just constantly back and forth, back and forth. Whereas if you know how long somebody's going to serve when they come in, you can plan for their release. You can get them programs. You can do everything else. This just creates kind of an unlimited amount of litigation over sentences. And to me, I just can't support something like that. But I appreciate the effort on the bill. I appreciate what you're trying to do here. But there has to be some way to do this in a much more limited way than to just say everybody over 50%. So not something I personally could support. I don't know where everybody else is, but I did just want to say that publicly. We've had that conversation privately, but it's just, that's my concern. So thank you.
I appreciate your comments. I appreciate you, our conversations about it. I understand your point. Okay, thank you. So one of your concerns is the fact that you hear these parole board hearings over and over. And so what this would do is if there's some extraordinary circumstance for that inmate and they have an opportunity for a second chance, then that would alleviate to me the back and forth with going before the parole board. So that's kind of what I was trying to get at to that end, but I appreciate your comments.
Representative Johnson.
I'm thinking if you could give an example, that's, of what this might look like in practice.
So
Just,
go ahead. Sorry.
just to give us a better idea of what it might look like. Thank you.
So thank you for that question. So we have right now a person that's been incarcerated, has been a model, if you would, inmate, has been doing well, but have a real serious medical condition that is costing the state, number one, to treat, the medicine for it, the back and forth to DeBerry for treatment. And if this person who have served pretty much most of their time, over like 70% of their time, and this is an extraordinary circumstance with his diabetes, health problems, things like that, this would allow a court of jurisdiction to take a look at that extraordinary circumstance and see if it's worth giving a second chance for this person to earn sentence reduction and things like that, so that they can move out earlier versus, so that we have somebody like that really in custody. And it's cost the state a lot of money. And they've been a good, model inmate.
Thank you. I appreciate that. Thank you, Chairman.
Any other questions for the sponsor? Seeing none, we're now voting to send House Bill 2832 on the full criminal. All those in favor say aye. Aye. Those opposed?
No.
The noes prevail. The bill fails.
That no was pretty loud, Mr. Chairman. Thank you.
Let's see here. Item 33, House Bill 2833 by Leader Camper.
Okay.
You recognize there's Amendment Code 15557. You wish to proceed with that?
Yes, sir. I need a motion in a second.
On the amendment. All right. You're recognized on the amendment.
Okay, thank you, Mr. Chair, Mr. Chairman and committee. What this would do is this is the Restoration of Dignity for Elderly Act. And so what this is trying to address, set up a pilot that would allow an elderly the opportunity to serve the remainder of their sentence in a less restrictive environment. Tennessee State Controller released a report in 2023 stating that currently Tennessee prisons are severely understaffed with a vacancy rate of 60% at one prison, leading to unsafe conditions for the staff and incarcerated individuals. Understaffing has been an issue since 2017. With this pilot program will help ease this overpopulation in Tennessee prisons. It's an initiative really to kind of give some not only humane treatment, but some fiscal responsibility too for elderly inmates who have served most of their term and they are over age 60. So what I'm asking here is for a pilot to just take a look at allowing the elderly to be released earlier in a less restrictive environment. It may include something like a device on them, restricted to home. It'll have some restrictions, but it would take them out of the prison system and put them in a less restrictive environment.
All right. Thank you for the explanation. We're on the amendment. Leader Lamberth, are you on the amendment or on the bill?
That's fine.
Okay, go ahead.
Leader, I know it's in the same situation. I sought you out and talked about this. I mean, 65 is not exactly elderly. So, I mean, I would argue that a lot of folks 65 and a little older than that is still in their prime. So I would worry about the effect this has on victims and survivors of crime. Same situation in the last bill. I know what you're trying to get at here. There are already some procedures within TDOC that allow for folks that are of severe age. If somebody's 100 years old and they're in the prison system and they're suffering from severe medical issues, they have some mechanisms to do that. This just seemed kind of like a meat cleaver approach to what might require a scalpel. So I understand what you're trying to do here, but again, with all due respect, Leader, I wanted to say, I know we talked about it privately, but just say publicly my reasons for not being a big fan of both the amendment and the bill. So thank you, Leader.
Thank you, Mr. Leader. Appreciate it.
Any other questions on the amendment? Chairman Olsey.
Thank you, Chairman. And I want you to know that calling somebody over 60 elderly just offends the whiz out of me. I'll just tell you.
I meant 65,
But
I meant 65.
you do understand too, we have a whole system of sentencing credits in the penitentiary that this would interfere with, trying to reach a normal, equitable thing for everybody in the penitentiary. Plus, we passed a bill here that I think somebody over 65 and has a life-threatening disease or a terminal disease, that they will put them in home care. So, but I appreciate your effort.
Thank you, Mr. Chairman. Thank you, Representative Hosey. I meant 65. But actually, the Sycamore Institute has said that, the population is aging. And over the last 5 years, 65 plus has grown at least 20%. And so the population is aging. And so I was just trying to get at a solution to help with the aging population and reducing the cost to the state of housing these older inmates. So that was kind of what I was trying to get to with this to help from a fiscal perspective as well.
Question on the bill.
All right,
On the
we're on the
amendment.
amendment. Question's
On the
been
amendment.
called on the amendment. Any objection? Seeing none, we're voting to attach Amendment Code 15557 on the House Bill 2833. All those in favor say aye. Those opposed?
No.
The amendment fails. We're on House Bill 2833 as is. Yes,
Then let
ma'am.
me take that off notice in that posture, Mr. Chairman.
Yes, ma'am. Without objection, House Bill 2833 be off notice. All right, we'll go
Mr.
to
Chair-
item number.
Mr. Chair.
Yes, ma'am.
Mr. Chairman, you all know that Representative Hakeem is out sick. He has a bill that I'm signed on to. Could I take that up at this point?
We will,
Oh, you
we
wanna
will
just
get those
kinda
bills
get
next
to
week.
that? Oh, well, there you have
Yes,
it.
ma'am. We will take care of that next
Thank
week.
Mr. Chairman and committee.
Let's go to item number 35, which is House Bill 279 by Representative McKenzie. You are recognized. You do have an amendment code 15533. Do you wish to proceed with that amendment?
We're on House Bill 279 or 28?
Yes, sir, 279.
Yes, that code is 015533.
All right. All right, you're recognized on the amendment.
Thank you, Mr. Chair. And this bill, I stood before you all before. We had a robust conversation about that. And at the end of that, I read the room. Thank you, Mr. Chair. And so what this bill does, as amended, is make that a shall. So just to kind of briefly give you a thumbnail sketch of what this bill does, it creates a provisional voter restoration process for those who only owe child support. All other court costs are done. They paid their debt to society, and they have an agreed order issued by a judge that they are now making adequate payment toward that arrearage that they weren't able to pay while they were incarcerated and or before that. And what you all's concern at the time was, the way it read was the judge may revoke the license. I mean, this provisional voter allowance if the person's not making adequate progress. Now it's a shall. If that person is not paid up, that petitioner or the judge, or they're tracking when everything goes through the courts anyway, when those bills get behind or that bill gets behind, they automatically get that judge automatically is to revoke that provisional voter registry, that voter allowance.
Any questions on the amendment? Chairman Halsey.
Thank you, and thank you. The issue, I think, was the legality of whether a judge can do that if the person is indigent and can't pay. Can you revoke that because they're indigent and take their voter card back? I think that was the problem.
Thank you. Thank you for that question. Yeah, it was a two-part problem. So as you read the actual bill, I mean, as amended, it says so that the court would give them court provided counsel and offer the person to be heard and submit proof of their financial inability to pay, and that may have a signed affidavit of indigency. So that is for that judge to decide. But if that person is ready, willing, and able, that person has to go through that filter, and he's provided he's more than likely he or she is provided a counsel to assist with that. So this bill addresses that as well.
Any other questions on the amendment? Seeing none, we're voting to adopt Amendment Code 15533 on the House Bill 279. All those in favor say aye. Those opposed?
No.
The noes prevail. The amendment fails. We're back on House Bill 279. Any questions for the sponsor on the bill? Question, Representative Hardaway?
Thank you, Chairman. Just wanted to inquire as to whether the sponsor wanted to roll this bill to the next week.
Well, we're on the last calendar, so it just have to roll down the list a little bit. Yes, sir.
To answer that question, I'm convinced that we need to do something. We're the only state in this great United States that has the child support. Again, child support is a huge responsibility, but voting's a right. Voting is a right. So if that's the only thing inhibiting us, 49 other states doesn't do that. So I'm good for a vote, but I want you all to know you're going to see me again because I just firmly believe that, and we're going to continue to work on this piece of legislation. But I'm fine with the vote today. But thank you all for hearing.
Any other questions for the sponsor? Seeing none, we're voting to send House Bill 279 on the full criminal. All those in favor say aye. Aye. Those opposed?
No.
The no prevails. The bill fails. If you wish to be recorded as a yes, please see the clerk.
Thank you, Mr. Chair and committee.
Item number 36, House Bill 2681 by Representative McKenzie. You are recognized.
Thank you, Mr. Chair. I think this bill will go. It's in a totally different direction, and this is a really, really strong bill because counterfeit pills have been found in every state. If you look at the DEA, these presses and molds, they can create up to $5 to $20 million in sellable pills, and they're happening every day. Fentanyl at a 1 kilogram is twice that. 2 milligrams. 2 milligrams is a lethal dose of fentanyl, and we're dealing with that every day. One statistic that I think is striking: in 2015, we had 169 deaths involving fentanyl. In 2021, we had 2,734. What this bill does is pull those pill presses. Currently, pill presses are in with bongs and other kind of marijuana kind of paraphernalia. It pulls that pill press out and makes that a Class E felony. It creates an avenue to where people are really held to task if they're caught with a pill press. That's what's happening. A lot of these users think that shouldn't be taking opioids, but they're making these pills that look exactly like that, and they're laced with fentanyl. So this bill does that. So with that, I'll stand for questions.
Questions for the sponsor, Leader Lambert.
Thank you. It's a great idea there. I carried a bill last year, made them illegal. So fully support the legislation. I'm a little worried, and again, we don't normally until kind of late in the year even ask this, but is there any intention on your Senate sponsor moving the bill? I notice it's not even on notice over there yet.
A great question. I was a bit concerned, but yes, that I had a conversation today. So there is intention to move the bill.
Any other questions? I got my eye on Representative Johnson. She had her finger up.
It was a pointing finger too.
Oh, it was a. Okay, that's good. All right, we're gonna question was called. We're gonna vote. Send House Bill 2681 to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward.
Thank you, Mr. Chair and committee.
All right, Representative Dixie is item number 49. House Bill 2415, you are recognized. Item 49, he is.
39. It should be. I thought it was 39.
No, sir, you're item 49.
Oh, okay. Sorry.
And
Thank
it is 2415, and you are in the proper posture, so proceed.
All right.
He
Yeah,
did.
motion.
He sure did.
All right. Thank you. Thank you, colleagues, for that. Approximately 500,000 citizens, because of felony convictions, accounted for more than 9% of the voting age population in Tennessee. They can't state coordinator of elections to create
and maintain a registry list of suspended voter registrations and restored registrations. Formulate a uniform procedure for automatically verifying an individual's eligibility to vote. Develop and implement a program to educate attorneys, judges, election officials, TDO staff, parole, and probation officers about the new process. It would help fix the competing restoration clauses in the Tennessee statute by eliminating the requirement to be pardoned by the governor. And it would also eliminate child support and the legal financial obligations that must be paid to restore suffrage rights, as these could be considered as civil matters. As part of the reentry services, the Department of Corrections, who is required to notify the released inmate of their automatic voter eligibility upon release and provide the released individual with vital documentation verifying their eligibility to register to vote. A list of financial obligation owed, if any, the process for registering to vote. It is important to note that under this bill, persons with a felony convictions are still required to pay their legal financial obligations upon release, including court costs, fines, fees, restitution, and child support, and certain infamous crimes are still permanently barred. And I'd like to add that there is no significant fiscal impact. And with that, stand ready for any questions or the vote.
Thank you for your explanation. Questions for the sponsor, Leader Lambert?
Thank you, Mr. Chairman. And I can't imagine that you have followed the track of the bill that was just up here beforehand, but I mean, that representative has worked for months to try to figure out a way to do at least a process that is a step in a direction. But yours just says automatic. I mean, you finish up your prison term, you get out, and we just pretend like it never happened. I for one, definitely can't go there. I mean, if you don't want to have to work through this process, don't commit the felony. You know, I mean, it's not that hard. There's millions of Tennesseans that haven't committed a felony. So, and if you have committed a felony, there's a pathway back. It's not an easy one. It takes steps. It takes purpose. It takes making yourself whole with society and getting back to the full rights of a full citizen. I want folks to take those steps. I want them to pay their fines and fees. I don't want innocent Tennesseans to have to pay for the choices of Tennesseans that have been convicted of felonies. So I'm fine with the pathway back, but it absolutely should not just be automatic, and it cheapens, quite frankly, the value of a felony for us to do so. So I'm willing to work on some sort of a pathway and improvement, but this is a step way too far, in my opinion.
Thank you for your comments, but I respectfully disagree with you. We have a term, we have a phrase that's called paying your debt to society. That's why we go to prison or you go to jail. You're paying your debt to society. Once you finish, you should be finished paying your debt to society. It's called the Department of Corrections. That is meant to correct the behavior that got you there to the first place. In Tennessee, it's become the Department of Punishment because we continue to punish people even after they've served their sentence. I think that you said people deserve a pathway. There's some other bills that have been presented. I think that we've always tried to take a little bite. But at some point, are we going to get serious about doing this? Had a bill earlier today that will help take a bite out of that. Met with a little objection for that. I mean, are we going to help people or are we not going to help people? We can't just pick and choose when it's comfortable for us. So what are we going to do? We have the opportunity to actually get people back to their lives. We've done plenty of studies that have shown that when people get their right to vote back, that they become involved in society and they become citizens and they get jobs and they work and the recidivism rate goes down. This is an opportunity for us to take the lead and do some stuff. We have a rate of almost 10% of people who can't vote in this country because they have felonies. People make mistakes. And sometimes it's not a choice. Sometimes it's a way of life. That's what the people have to do to survive. And it's not like people wake up one day and say, oh, I want to sell drugs. Or this is what I want to do. Sometimes it's just a matter of survival. But I appreciate your comments. And I thank you, Mr. Chairman, for allowing me a few minutes to speak about this bill.
Representative Johnson.
Thank you. And thank you for bringing this bill. I agree with you wholeheartedly, and many states do that. Once your time is completed, you can register to vote. I have serious problem with the child support issue when we have a group of folks who do not have felonies who haven't paid their child support and they can go and vote. We don't take their voting rights away. Then you have a group of folks with a felony who have done their time for that crime and they are penalized because how could they possibly pay child support because they've been in prison? And so the folks that could, be out working and pay their child support are not paying it. How do you? It seems unconstitutional, and other states have deemed it unconstitutional to take that right away from one group who hasn't paid child support and not take it away from another group. And I see that as a serious problem, and I appreciate you for bringing this bill.
Any other questions for our sponsor, Representative Hardaway?
Thank you, Chairman. And I thank you for the bill, sir. I believe that the sentence is the sentence. And when the judge says, this is what you've got to do, once you've done it, you finish paying your debt. And you should be able to move back into full citizenship. It just doesn't make sense to me that we would have you pay your debt to society and then we're going to string you along a little longer and take your dignity, take your self-respect, and perhaps even push you back into the same mode that got you in trouble in the first place. So I'm a believer in your bill. I think it ought to be automatic that you either paid your debt or you didn't. Once you paid your debt, then you ought to be back in society with full membership. So I thank you for your bill. Hopefully my colleagues will have a sense of favor for it.
Any other questions for our sponsor? Seeing none, we're now voting to send House Bill 2415 on the full criminal. All those in favor say aye. Those opposed?
No.
The noes prevail. The bill fails.
Thank you, Mr. Chairman.
All right, members, last bill of the night. Let's go to item number 82. House Bill 2601 by Representative Johnson. There are a few amendments. Which one would you like to proceed with? Amendment Code 17220. You are recognized on the amendment. Do you want to explain the amendment or you want to adopt the amendment? And does it rewrite your bill? Okay. All right, we're voting to attach Amendment Code 17220 on the House Bill 2601. All those in favor say aye. Aye. Those opposed? The ayes prevail. You adopt or on the bill as amended. You're recognized.
Okay, I have someone here to testify.
You want to turn on your microphone? I can't hear you. I'm
Or
sorry.
bring it to my face.
Sorry.
I have someone here to testify if we could do that first.
Okay. We will go out of session to hear from Bailey Jones. You can stand at the podium or sit at the chair, your choice. Okay. Well, if you will, introduce yourself for the record, and then you'll have 3 minutes for comments. Make sure the red light is on there on the little.
So sorry.
Okay.
Okay, my name is Bailey Jones. I've spoken to most of you personally, but for those of you who do not know me, I'm a mom and advocate for sexual assault survivors, which is a category I fall into myself. Please feel free to ask me any questions about what I've experienced because I've healed from a lot of it and I'm very open to talk about it, obviously. Some of you know I was raped 2 miles from where we sit today on Dew Street in East Nashville. I was almost murdered when my rapist choked me to keep me from screaming for help, obviously. After I was assaulted, I was taken to Nashville General Hospital to have a rape kit done where a sweet sexual assault nurse examiner had to take what seemed like countless swabs from my vagina scraped under my nails, and took pictures of the bruised, bloody state of my body, including my genitals. After feeling immensely violated from the violent rape mere hours before, on top of the forensic photos that left me feeling more vulnerable than ever, I thought the worst of it was over, and I was sadly very wrong. The police officers, who were probably not older than I am today, led me to a small, dimly lit room, which was very comparable to an interrogation room. Not a place you really want to be. These two male officers towered over me, a 19-year-old, 100-pound young lady, and asked me, was it oral, vaginal, or anal penetration? Not really a question you want to hear ever. I asked them if they could sit down and ask these uncomfortable questions. They told me that that wasn't something that they could do. Yet again, I was made to feel like I was 3 inches tall for what felt like the millionth time that day. I felt like I was the one who committed the crime. During the 3.5-year investigation of my rape, it constantly felt like the burden of proof was on me, the victim of this crime, this god-awful crime. I was kept in the dark. I was handed off to multiple detectives, one of which lost my case notes. No one even knew what I was talking about when I called every day for a status update for 6 months. It turns out that the detective left said case notes in his desk when he got a promotion, and I can only assume that the pictures taken by the same nurse were in that same file. Pictures of my vaginal bruising included. Aside from the complete lack of justice in my case, I was treated like a nuisance, like I had to prove that the sex was non-consensual, that I had to damn near lead the investigation myself. I am no law enforcement officer. I implore you to keep this bill pushing. It was a bill that was drafted by survivors of sexual assault for survivors of sexual assault. This was a lived experience. All of this bill was something that we lived through. We want to make sure that the women, children, and men never have to experience the heartache that we endured. Your children, your women. Please consider our struggles when you make your vote heard today. And thank you to the committee members for your time and kind words. And thank you to Gloria for working as hard as you have on this. If you have any questions.
Thank you for being with us today. First on my list is Leader Lambert.
Jones, I know we visited privately about this, and you are very brave to come here and talk about this. I'm sorry that you have to. I'm sorry that and I know that you've come up here in a place that your grandmother served in for years. I served with her.
Yes, sir.
Please give her our best.
Yes, sir.
But it makes me angry to hear your testimony.
It makes me angry
upset.
to give it to you.
Yes, ma'am.
Mhm.
And so I think the least of which is to ask that folks get better training on this, that officers do. I get it. Officers get callous sometimes. They handle hundreds and hundreds of cases. But what happened to you should never happened. And when
Exactly.
you came to a law enforcement officer for help, they should know what to do and to try to make an unbearable situation at least a little bit more bearable. And so, again, I appreciate your testimony. Thank you for continuing to work with Representative Johnson and others. None of us understand what it's like to sit in that chair and do what you're doing right now. We never will. But thanks for doing it.
Thank you. I appreciate that. I'm tearing up.
Representative Towns.
Mr. Chairman, this is personal to me because I've known Bailey since she was a little girl, a little bitty girl. Her mother and I served together. She was my classmate. Sherry was my classmate. She came in with me. This is a horrible situation, and I just think we're compelled to try to do what we can. It's a real situation. People that we know is touching us. This touches me and touch a lot of us here because we know these people. She's still young. She's just, really, really young. Okay. And so I want to thank you for your bravery too. And your strength and your courage, and try to see what can we do to try to help Gloria get this bill passed, because this is just a sick situation to me. Mr. Chairman, thank you.
Yes, sir. Thank you. Representative Hardaway.
Thank you, Chairman, and good evening to you, ma'am. I certainly appreciate what it took for you to have to come and sit to look at us and to relate your story. the insensitivity of what you just described, it's really unnecessary. If the proper training is done, and I'm speaking just from some experience with other law enforcement situations, that if they knew better, they do better.
Yes, sir.
So if we put the correct procedures in place, get the correct training in place, and of course, we need to be selective about the personnel,
Yes, sir.
put the right people in place, then it will be a situation that will seem more like justice is being delivered to you. And that's the ultimate goal.
Yes, sir.
The process itself should reflect the ends that we're trying to reach. So I salute you for having the courage and the articulation was eloquent. So thank you for being here.
I appreciate that. Thank you.
All right, Representative Fritz.
Thank you, Mr. Chairman. I just want to commend you again for your courage.
you.
I can't add anything to what these other folks have said, but such a brave young lady. Bless your heart. I'm sorry you had to go through that. And again, you've definitely earned my respect for the courageous person of the day.
Oh, thanks.
All right, we'll go back to Representative Towns.
Look, Bailey, I do have one question.
Yes, sir.
Were they able to prosecute the guy that would catch him?
So I know who it is. To tell this story in full, I would have to say that almost a year to the day after he raped me, he shot someone in the face with a shotgun and was only given probation for that. Glenn Funk decided that he was not going to prosecute the man that raped me because the DNA evidence from my sexual assault kit that I spent a lot of time mulling over in my mind was degraded. They could only prove that it was male DNA due to the state of the DNA. So no, he never saw the inside of a jail cell.
Not good.
And he's very obviously still continuing these terrible actions.
Mr. Chairman, this is the reason years ago I passed a bill, you don't know this, Bailey, that in the event that we were able to get new DNA, we can still prosecute because was it reported? It's already been reported.
Yes, it was reported immediately.
So if we catch him 20 years later, 25, 30 years later, we still can prosecute him.
Hmm.
So we're going to cross our fingers and think that and hope and pray that something comes up so we can prosecute this bastard.
Yes,
Okay.
sir.
It's already on the books to be done.
Yes, sir.
Okay. Just for your information. Okay. Mr.
Thank
Chairman,
you.
thank you.
Any other questions or comments for our guest while we're out of session? Seeing none, thank you so much for being with us, sharing your story with us. And I apologize that you've been here for many hours
That's
waiting
okay.
for this opportunity.
That's okay. I'll wait as many more hours as it takes to get it done. There we go.
We're going to go back into session. Representative Johnson, we're on your bill as amended.
She's got her grandmother's spunk. This bill would require that any law enforcement officer that works directly with victims of sexual assault complete sensitivity training to help them understand what the victim's going through, how best to question them to elicit pertinent and accurate facts when it's freshest in their mind. According to a survey of law enforcement officers sponsored by the U.S. Department of Health and Human Services, officers that received additional training on sexual assault sensitivity reported feeling more confident in dealing with these cases and had better outcomes of victims feeling heard and actually wanting to work with law enforcement on these cases compared to those who had not received the training. Many victims feel intimidated and vulnerable when being questioned, are less likely to work with officers along the way. And because of that, they don't pursue it or stop it. And a lot of people, because of this, do not report. So this would help us be able to take more rapists off the streets by, people bringing these charges and because they stay with it when they feel like that they're being considered as a person and they continue on to help the officers with the investigation.
All right, first on my list is Chairman Holsey.
Thank you. And Representative, I'm for the bill. I just have some logistic questions. The 16 hours of post, and I should know this, I'm on post. It used to be 4 hours of training for sexual violence cases, and it dealt specifically with the right way to ask questions and empathy. How did you get to 16 hours? I'm just asking if that will make that kind of difference. And not only that, you have to understand that in post, you've got required classes all the way through this thing in the basic police academy, and you also have them in the retraining section. That was one question. The second question is most hospitals, I can remember that all hospitals had policies of when a rape victim came in, who they would assign to that, the room that they would put them in, the protocol that they would go through to make them the most comfortable that they could and show the most empathy that they could. Have we just fallen by the wayside with that? And then the third thing is, if TBI can't get to a rape kit in 90 days, what happens?
Well, honestly, initially we addressed rape kits in this bill, but it made it a lot more complicated. So we're going to do it. She wants to do it in sections, and we decided to address the training first. But the reason the 16 hours result is that is what has been demonstrated in research to show that where that difference is made in how many people come forward, continue to help with the investigation, and have more successful actually outcomes from the investigation. That's what it's demonstrated to show this longer time. And I think you know how it is these days when we get to hospital emergency rooms and all of that, how things get so crazy sometimes that perhaps they're not really thinking about all of those things and it's not getting done the way it should. I know there's a way that we all think that it happens or should happen. And certainly if you have been in law enforcement, you have a better idea. But that's just not. When this situation first came about and she testified the first time, I heard her talk about this publicly. So many people came forward, so many women came forward saying this was my exact experience with the police and with being, and why they just kind of dropped off and didn't continue on with the officers in the investigation because they felt so small and like they weren't heard and as if they were the perpetrator and not the victim. So many women came forward now and gave more the opportunity to testify. They didn't have the courage that Bailey had to come forward today. They're working on it, but it's happening a lot.
Leader Lambert.
Roll one space, please.
Representative Fritz.
Thank you, Mr. Chairman. Thank you for the bill. Fully support that. You know, some of our local police and sheriff's departments do some training with Ridgeview just for crisis intervention. I just wonder if there's an opportunity to engage our mental health professionals in establishing what this 16 hours looks like or whatever it happens to be. I'd be glad to help you with that if you need it.
Yeah, absolutely. We see that at Helen Ross as well. And there are some crossovers there, certainly.
All right, Representative Leader Lambert.
Roll one space,
Representative Russell.
please.
Thank you, Mr. Chairman. And I'm all about this bill too. It seems like a good bill. Have you worked with Post any to come up with their thoughts?
I have not talked with them, but we that is obviously in the plan. But there are so many programs out there that it's not like you have to reinvent the wheel. You can draw down from what's been successful in other places because I mean there really is a demonstration of success across the board with these trainings.
And does this only involve personnel that are investigating sexual assault cases, or does it involve all law enforcement?
it involves people who would be addressing that. That's one of the things that I actually talked with Leader Lamberth about. Initially, that's why I chose this amendment, because the other amendment, it made it sound like you also wanted lab technicians and things like that to get that training, but we've removed that.
So it would be just for a specific group of people that specialize in this type of investigation.
Anybody that might be responding to that type of a crisis, yes.
I would be all for it. I wish that we could maybe talk to Post and get their opinion. I don't know how y'all feel about rolling into the hill and maybe get together with Post before next week, but I like the bill, so that's all I've got though.
Leader Lamberth.
Thank you, Mr. Chairman. I was going to make a motion there, but I will say that in response to that, I mean, I know there's some victim compensation fund language that's changed in this. There's some hours that we could work with Post on. The bones of this seem strong, and we are getting down toward the end of the calendar. And I know we have a whole lot of other bills to deal with. It seems to me like the structure of this is good enough to move on to full. So I can't move previous question at this juncture. I would have, but it just seems like a bill to me that we can move on to the full. And I trust Chairman Hulsey, if there's any tweaks that need to be made to work with Post. You might not have heard from Post yet, but I bet you might get a call after this if it passes this committee.
Happy to talk with them.
Representative Davis.
Thank you, Mr. Chairman. And so my question has to do with, in section 6, it talks about the SART team has oversight authority over local law enforcement agencies handling of sexual assault crimes and power to conduct audits and reviews of the sexual assault crime investigations. So when we passed that legislation last year with regard to those SART teams, it was the intention of the legislation, and as I carried it forward, it was not to be a mandatory sort of response team. It was to be something that we hoped would be collaborative, that people would be involved with. And so my concern is that here we have something that people may or may not be involved in, and that we're making this be mandatory and have oversight with, when they may not be very structured sort of sexual response. Does that make sense? And so that's my concern with that language.
Well, this language comes from suggestions that initially there was a little bit more requirement, but this removed that requirement. And I think that this falls in line, and this is what we were told would be appropriate language.
I'm sorry, I don't understand appropriate language for who? By whom?
For this bill, for this to work, that this would be an oversight authority that would be potential and possible for this bill.
So have you spoken with law enforcement to, if they're approving of this language, or if they're supportive of having this oversight authority by the SART team?
Not with the SART team. I have not talked with them, but when we talked with legal, they said this would be appropriate.
Okay. Thank you.
Representative Towns.
I move previous question, Mr. Chairman.
Previous question was called. Any objection? Seeing none, we're voting to send House Bill 2601 as amended on the full criminal law. Those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward. Members, I appreciate you hanging in there with us today. We did move through the calendar considerably. We are going, all remaining bills will be, they'll just stay on this calendar. We're on the final calendar, so they'll just stay here. So we'll pick up next week. We're adjourned.